Hi, good morning. My name is Kenneth Johnson, and I'm making a presentation, a persuasive speech video here with my audience members, Mrs. Christiana uh, in Canteen, Mr. Alan Bichet, and Mr. Micaiah Noah. My classmates, thank you all for participating. We'll be going to screen share so that I can make the presentation. And can you all see the screen? Yes. Okay. My name is Kenneth Johnson, and in 1985, I went to prison, and these photos right here were taken while I was in prison when I arrived at prison. This photo right here was taken as soon as I entered the prison at Chino, at the California State Prison in Chino, California, in 1985. This is another prison during picture during that same term that was done in 1987. The question I will be proposing to you is that the California Department of Corrections, as you can see up here, the California Department of Corrections is a state agency, just like the DMV, Department of Water or Power, Department of Children's Social Services. You know, there's about 28 departments within the state of California. In the departments in all those departments, they all have uh, in this state, we have a state law called the Information Practice Act, which protects the rights to privacy of every individual for their personal information. So if you go to the DMV and they take your picture or for your driver's license or personal information, or go to the Department of Children's Services or the county building or any kind of Medicare, they take your information, you know, your unique, your biometric data. They might take a picture of you, like the DMV, or they might take your personal information, your date of birth, your height, your weight, your name, your social security number. All these things are personal to you as an individual. And the DMV would not let, say, if you somebody who got a ticket at the court, and the judge gave that person restitution or some kind of community service, and sent them to the DMV to do the community service. Once that person showed up at the DMV, which is a state agency, the DMV wouldn't allow that person to take your photo for your driver's license because it's protected information. Only the state employee would be allowed to take your information, which is, appropriate. So this presentation that I'm going to be making is regarding the state agency, California Department of Corrections. And as you can see, my name is Kenneth Johnson. I'm this person who these documents are pertaining to. Um, so let me begin. Upon arrival at the Department of Corrections on June 25th, 1985, my photo was taken by inmates who were the workers. The officers that worked there, the guards, didn't take the photo. Inmates took the photo. Inmates also took these fingerprints on this fingerprint card. They wrote down all these particulars: my date of birth, my name, my CDC number that they assigned to me. The number that you can see is right here on this picture, D09160. All this happened in 1985. In 1995, I was arrested again for a crime of burglary, and it carried a crime of 246 years. But under the three strike law, all these enhancements were applied to the crime. They were nonviolent felonies. They weren't for murder or anything like that. But I also got an extra charge because instead of telling them my name was Kenneth Wayne Johnson, I only told them my name was Kenneth Johnson, and they gave me some more time for that. As you can see, the crime carried 246 years, but because of these enhancements and this law right here, the three strike law, the sentence was enhanced. Here's another case, the second case I had. Uh, Also, same situation, just a different courtroom. The first one was in Torrance, this was in Compton. And again, as you can see, the crime carried 3, 4, 6 years, but because of the enhancements, it added more time to the sentence. What happens in the court at the trial, the Department of Corrections sends a certified letter to the court because the DA requested. It was requested by the DA, and the Department of Corrections certifies that these records that they're sending, and they're admitted in the evidence. So these are the evidence. This is the record of what happened in 1985. This is me coming into prison at Chino. And this is me discharging in 1988, or I paroled in 1988, and then I discharged 1 year later. So I no longer had this number. It's called a prior, a past prison term, and it's a prior. However, in 1995, it was sent to the courtroom and used by the DA. This is the 1985 record where when I got to Chino in 1985, inmates put a print right here. Inmates took these fingerprints, as I already explained. And inmates took these photos. This photo right here, this photo was taken under the same number during the 3 years that I was doing for the 6-year term in the 1980s. In the courtroom, during trial, after trial, to prove that I went to prison in the 80s, the DA brings a fingerprint expert who has a fingerprint card of his own. Then he takes my fingerprints in the courtroom. So he took my prints in 1996 during the trial, and after he took the fingerprints, my name right here, Kenneth Johnson, it was admitted in the evidence. And as you can see, in 1996, he took these fingerprints and matched them to the fingerprints that's on the fingerprint card that the inmates took. As you can see, the same areas, he put his numbers right here for the fingerprints that he said matched the fingerprints that he took. So he matched his prints that he took to the prints that inmates took. And as you can see, he put his marks on my fingerprint card, the one from the 80s, saying that he matched them to his card. When the DA explains this to the jury by explaining that these are documents from the California, as you can see right here, he's saying these are certified records from the Department of Corrections. And that's why it has the state seal right here. And it also has a thumbprint on the abstract of judgment. So he explains this to the jury. And as you can see a little better, it bears the Department of Corrections seals. And he also explained that it had the thumbprint right there in the top corner. And that means that I got to prison on that abstract of judgment in 1985. And he's telling the jury this in 1996 at jury trial. So the jury hears this information and they turn in a verdict form. In this case, the jury determined that it was true. The judge takes this true finding that the jury makes and called it a strike, and the judge sentenced me to 25 years to life for count 1, and he added 2 5-year priors right here, making it 35 years, and it ended up being 37 years to life for this crime. The crime carried 246. Again, in the second case, same thing. The judge gave me 25 years to life, and he added 2 5-year priors for a total of 10 plus the 2, because I didn't give him my full name, so it became 37 years to life. And this happened in 1996. So sometime in prison, I appealed it, that the fingerprints and the photographs that were used to prove my priors were done by inmates. So I asked the Department of Correction to let the court and the jury know that the records were done by inmates and wasn't rolled by the officers. The department stated that right here, there are no means to confirm your claim that these documents were prepared by inmates. Therefore, CDCR, the California Department of Corrections, will not be contacting the district attorney, Department of Justice, or the FBI. They refused to do it. Then I appealed it again. It's signed by the warden right here that they wouldn't do it. So I appealed it again, and when it went to the next level, Officer Vargas on July 14, 2009, Officer Vargas confirmed that during the mid-1980s, permanent work crew PWC inmates did in fact fingerprint incoming inmates. However, the inmates were under constant supervision of correctional staff and did not violate department policy and procedure. And they said I signed my fingerprint card. And they basically said here that it was okay for inmates to do it. I also wrote the letter to the warden, and the warden said right here that under the government code, which disqualifies a felon from being employed as a peace officer, it didn't stop the use of inmate workers to prepare my 1985 fingerprint or to take my photograph. I also appealed to the law enforcement portion of the California Department of Correction. And in that interview, in both interviews, they recorded the interview, but in this letter, in my appeal, they stated that they didn't record the interview. But any interview done by the internal police of the California Department of Correction, they interview and take pictures of all your documentation. But in this letter, they say they didn't. So that being the case, I wrote to the Secretary of State, and Secretary of State to the Archives Unit, and I asked what were the laws in 1980 when I went to prison in the 1985. So he sent me a letter, and they sent me the documentation of what the rules was back in the 1980s when I went to prison. Here they're showing that in 1995, the department changed the rule in 1995 so that they could say inmates were allowed to do what they did in the 1980s. But this law didn't become law until in the 1990s, 1995. So currently in the Department of Corrections, under information practices, any person whom the department maintains a record or file concerning personal information has a right, basically, to request amendment to correct outdated, inaccurate, or incomplete information. So I've been making my appeal that I'm requesting that the records be amended. Not that they're outdated and not that they're inaccurate, because that is my information. That is my picture. That is my fingerprints. However, I'm saying the information is incomplete because the duty to record the fingerprints on the fingerprint card and take the picture was done by convicted felons, and it wasn't done by the police officers or the correctional employees at the prison. And these are laws where in 1979, what the laws that Alex Padilla sent to me from the Secretary of State sent to me, and in it shows in 1979 that CDC adopted what a peace officer is. These laws remained in effect all during the 80s, and it outlines who a peace officer is and what the employees' responsibilities are as peace officers. It also states and defines who a peace officer is. Nowhere in here does it state that an inmate or a convicted felon is a peace officer or an employee for the California Department of Corrections. At the same time, they also adopted, the Information Practices Act. And Information Practices says that information in all records and files of the department which pertains to individuals, including inmates, employees, or other persons, will be collected, maintained, amended, and disclosed in conformance with all requirements of the Information Practice Act. It also states the employee responsibility. employees of the department who are in any way involved in collection, maintenance, use, and dissemination of information about individuals, remember the individuals are the inmates, employees, or other persons, will do so in compliance with provisions of the Information Practice Act. This law was signed by the warden, the director of corrections, August 8th, 1979, and it remained the law throughout the 1980s. And it's certified by the Secretary of State that this is an archived document and original document, a copy of the original that was filed by the Department of Correction, what their rules were. This is what it looked like in the rule book back in the 80s. This is a microfilm of what it looked like in the 80s. And in 1992, they changed the rule, but it still said no inmate or parolee shall prepare, handle, or destroy any portion of department record containing personal information. So basically it was saying inmates aren't supposed to, touch department records with personal information in it. This right here is the rule for R&R for the receiving, for the initial intake procedure. In it, it states that the receiving responsibility that the R&R sergeant shall make a print of arrival's right index on the commitment document. So that print you saw up at the top that was on the abstract of judgment that was put there by an inmate, this is the rule that says it was the R&R sergeant's job to do it when I arrived at the prison, not an inmate. Inmates also, the R&R sergeant is also responsible for taking 4 sets of fingerprints. Here's another law, that the Penal Code, that says that the fingerprints are to be done by that the warden or the director of correction is responsible that fingerprints and other identifications are taken when a new arrival comes to the prison, and 1 copy shall be transmitted to the Department of Justice, and another copy goes to the other copy goes to the FBI. So there's 2 out of the 4 copies. 2 of them stay in the Department of Justice, and 2 copies, 1 copy goes to the FBI and 1 goes to the State Department of Justice. This also is Government Code 1029 that says if you're convicted of a felony, you're disqualified as peace officers. So it shows that anybody convicted of a felony can't perform the duty of a peace officer. You're disqualified. Here's others saying that for evidence in a courtroom, that the writing has to be made within the scope of duty of a public employee, and that the sources of information and method and time of preparation were such as to indicate the trustworthiness. These are more rules regarding the training, and that all employees will be provided the training on the policies and regulations, and only those employees with a need to know shall be permitted to have access to department records containing personal information. Only employees. Again, inmates wrote these prints. Inmates took this information down. Inmate put the print here that the rule says the sergeant was supposed to put there. And the sergeant also signs here at taken by on the fingerprint card, which gives it makes people think that the record is official, that it was done the right way, but it was done by inmates, even though the sergeant signed off right here. And you can see it's the CDC-138 fingerprint card. This card is the card that was matched in the courtroom because they knew my picture, that was matched by the fingerprint expert when he testified to the jury that the prints that he took right here matched the prints that were done by inmates in prison. And so in it, the court this is the sentencing again, where the court gave me, this is for a total of 37 years. Here's another case where I got 37 years, and in both of them together, they said for a total of 74 years is what I received for the two cases. For this case and this case, I got a total of 74 years and 8 months. And they sentenced me, they did all that, and it's based on records that were done by the inmates. These are official records from transcripts from one of the cases. I have 2 sets of these, and these are official clerk transcripts from the case in Compton and the case in Torrance. But today I stand here as a student with you after serving. I got out parole after CDC sent these records and certified them, and they were used in court to give me 74 years to life. Actually, it was 3 life sentences. One of them they stayed on records that were certified by the California Department of Correction, because they certified their records under state seal. After all of that, I did 25 years, 6 months. I paroled July 30th, 2020. And last Friday, I'm happy to announce that my parole officer sent me this text. And he said, Johnson, a board of parole hearing, a BPA's judge discharged you effectively today. This was last Friday. You are a free man. No need to report to parole. Enjoy. So I'm happy to announce that as of today, I'm off parole. And even though I did all that time, I'm off parole, and that's behind me now. So thank you for participating and allowing me to share. I'm gonna stop the screen share now and stop the recording. Oh, the question I present to you though is the panel is in make your own decision, and hopefully I wasn't trying to sway you one way or another, but the question that's being posed, are the records, in your opinion, incomplete? Because the official duty wasn't performed by the state. It was performed by convicted felons serving up to life sentences in prison. And that's my presentation, and thank you for participating.